Good morning, everyone. Thank you for joining us for this lay legal webinar this morning.
Sound check.
Can everybody hear me okay? Good morning. Okay, glad you guys can hear me. So it's about 9:30 now. We'll get our webinar started. It's slated to last until 11. So we'll probably go about an hour and 15 minutes and then have a question session at the end. But feel free to use the chat box as we go through the presentation. We want this to be pretty interactive and kind of form a discussion too while we're here in this webinar. So we'll be answering questions as we go along, and then any questions that didn't get answered, we'll make sure we get them at the end. So today for our webinar, we're going to be talking about the Arizona legal system. We've got Doreen Nicholas from the Coalition, and then Alicia Fessel from the Community Legal Services Organization in Phoenix. And then I will be sending out the presentation slides in an email after we're done with this webinar today, and then you can request a certificate through me as well. You can just respond to my email and I will get back to you and send them out to you. So take it away, ladies.
So we're going to get started. Good morning, everyone. This is Doreen.
This is Alicia Fessel. I work for Community Legal Services. We're the local legal aid organization here.
So we have a real live attorney in the room. So we're going to get that perspective from court etiquette and some of the differences in the legal system from her. So use your chat box and let us know how many of you do legal stuff, do legal advocacy, go to court with victims and survivors. Okay, Yvette wants us to speak a little louder. Okay, we'll do that. Is that better, Yvette? Okay, you're a victim advocate. Christina, do you do any legal stuff, assist folks when they're trying to get an order of protection or go to court? Yep, lots of time in court. Okay, great. So hopefully some of this information will be helpful. There's a link in the presentation for a handbook for victims and survivors on how to represent yourself in court in case there's not an advocate available for somebody or they can't access an attorney. So Stacy will make sure that that is attached to the link is in the email that she sends you. Mm-hmm. So let's get started. So our objectives are to make sure you have information so you can be more effective when supporting victims and survivors through any court process. We want to give you information to share with victims and survivors when you're preparing for court, when they're preparing for court, and understand how we and the survivors we work with can be more effective in court from an attorney's perspective, and how advocates can assist attorneys in some of the cases. So if anything else comes up that you want to talk about too, put that in the chat box and we'll make sure to get to that. Anything to add to that, Alicia?
No.
Okay. So some basic guidelines. So how you look, how you dress, how you present yourself is really important for you and the survivor. It's always important to be well groomed, clean, neatly brushed or combed, comb your hair, your beard, your mustache, whatever you got going on. And sometimes it's a good idea for folks to cover tattoos and piercings if they can. If it seems over the top, that might be distracting to the judge or other folks in court. Try to dress as professionally as possible. Collared shirts, suits, dresses with sleeves, nice slacks, etc. And, part of the work that you do with victims and survivors might be helping them access some appropriate clothing, because we know that many of the survivors that we work with, especially if they come into our shelters, they don't have a lot of clothing items that may be appropriate for a court. So think about that as far as resourcing. If you are working with someone that's going to court and they don't have the proper attire, how can we access that? And there are a lot of resources in the state to do that. Anything to add to that?
Yeah, and I've found that when you say professional attire or appropriate attire, that can vary for people depending on, their culture, what neighborhood they come from, how people dress in that neighborhood. I mean, I used to tell clients to dress like they're going to church, or, if they're Jewish, I'd say dress like you're going to shul. But you don't want to look like you're going to the club. And I think a lot of people will think, I'm going to wear my 4-inch heels, You really need to, you just don't want the attention to be on the way you look. You want it to be on the message you're trying to give. So it's super important.
Good. Okay, you want to take this one?
Yeah, it's always good to arrive early, but and some of the minute entries, the parties are actually required to get there early. So make sure you look at that. A lot of times in family court, judges will want the parties to try to settle the case, and so it will often say that the parties should meet 30 days ahead of time, and they don't. And so if they have not met and tried to discuss settlement, they're required to really show up before court and try to have a discussion there. And a lot of the lazy attorneys will just show up to court the day of and 5 minutes before try to get your client to settle. So show up early, make sure you have plenty of time so you're there with them if they want to talk to the other side. It can be a little intimidating when they're being thrown into something at the last minute. They're already stressed about court, and then here's this opposing side with their abuser trying to talk to them and get them to settle, and they feel very stressed, and maybe I just need to make a decision right now, and they haven't had time to think about it. So give plenty of time just to get checked in, go to the bathroom, have a minute to just sit and relax and take deep breaths, things like that.
So how could someone check the minute entry? How do you do that?
So we'll talk later about, I think there's a link in here for ECR, which is the electronic court record. I recommend that everybody sign up for that. What we do at our organization, what we've done in the past, is we've requested that our clients sign up for it, which is a really simple thing to do online, and then share the password with us. Of course, we tell them it's confidential, but then we can actually see the minute entries too, rather than relying on our clients to bring us a giant stack of paperwork, and usually the papers are all out of order. So ECR is a wonderful resource, and it's super easy to set up.
And then the opposing counsel?
Yeah, sometimes there is opposing counsel. Sometimes there is just the opposing party, and we certainly don't want anyone trying to contact the abuser, and that's a whole other webinar that we could do. But the parties are actually supposed to engage in settlement discussions, as I mentioned, and if it's just your client and then the abuser, under no circumstances should they have to discuss settlement. If there is opposing counsel, however, they are required to talk to that abuser's attorney, basically. I usually don't have a lot of contact with the opposing counsel, but they know what time they have to be there. They should be responsible, but they usually aren't. So show up early. Hopefully they will come, and they will try to discuss the settlement with you, because you want to go into court being prepared and saying, Your Honor, I have done what you asked me to do, whether or not they did it.
Good. Okay, this is a really important one for any kind of venue, I think, but particularly court. It's really important to turn off cell phones or other electronic devices upon entering the courtroom. You and the survivor should try to avoid making calls or sending text messages. If you need to make a call, leave the courtroom. And this one, have you seen this happen?
Oh, yeah. And even attorneys, we can be guilty of this too. I mean, I always turn my phone off in the parking lot, just so I'm not even remotely running into any issue where I might have the phone on. But a lot of times I know it is tempting to be sending text messages or something. You don't want the judge seeing you on your phone. It looks like you're disinterested. So you definitely, if you have to, you in the middle of a hearing for some reason, I don't know why you would need to, but alert the judge. Don't just start talking on your phone in the middle of court. I have seen that happen.
Yeah, you don't want the judge to take your phone, or you don't want to get kicked out of court, right?
Right.
So it's really important to avoid raising your voice. As this says, every proceeding is recorded, and FTR is the program they recorded, the For the Record program. So microphones are very sensitive, so you don't need to raise your voice. And then the next one,
Yeah, so at the table, you'll see there's, the microphone is like built into the table, and there's a little button you can press to mute it. And if you think that just maybe speaking quietly is enough, it is not. It will pick up every single thing that you say. So you have to press that button. If you're, for some reason, in a courtroom that doesn't have that button, you need to move really far away from that. Because I've heard every conversation. I do watch these videos, these recordings. And by the way, if you want to get a recording of the FTR, you can just fill out a request, and you can watch that video later. And sometimes your clients may want to. And for protection order hearings, I believe they are completely free. It used to be like $30 for a family court CD, but those are actually pretty good to watch later on. And because a lot of times I assist people with preparing for court, but maybe I don't appear in court with them, so I can watch that and see what actually happened.
Oh, that's good to know.
Mm-hmm.
That might be a good tool to prepare a group of survivors for court, or going to get an order of protection, or those kind of things, by using one of those as an instructional kind of thing. Oh, good. So it's really important to behave respectfully. And these are just some basic common sense things. Don't be chewing and snapping your gum. Don't cuss and use foul language. Don't be bringing your lunch or your French fries into the courtroom. So no outside food or drinks, or your pumpkin spice lattes. Alicia's got one of those. No children in the courtroom. Don't cross your arms and look all defensive and those kind of things. Don't speak out of turn, and that includes sighing. And I know that many times that's a challenge for survivors, especially if their perpetrator is spouting off or saying untrue things or getting agitated themselves. If your client brings a lot of support, confirm that they can do all of the above. So your client or survivor that you're working with needs to convey this stuff to their sister or their mother or their brother or whoever else might come to support them in court. Your demeanor does matter. Judge, look at that and take that into consideration. We don't want anything to cloud the judge's decision-making in a negative way. They'll look at who is believable. They'll listen for that. And many times it'll land on the more respectful litigant, the more respectful person in that case. Anything to add to that?
Yeah, so in family court, except for, maybe like an order of protection type case, in custody cases, a lot of people will say, well, my child wants to come to court and testify. That is not allowed. Kids do not get up there in front of their parents and choose, in case you guys don't know that. So a lot of times your clients may say, well, I want to bring my child. No, under no circumstances would you want to do that. Language is, your body language is super important. Many times, it's not just sighing, it's just rolling your eyes or even just getting angry. Judges watch this all the time. So you don't want your party doing that. If the other party does that, that's great, because then that makes them look terrible in front of the judge, but you don't want your client to look bad. Another thing, I had a client come to court just with her girlfriend, but then the other side had 20 people that showed up, and it was just a mass of people, and the judge, you could tell, was just so irritated because it was very confrontational, and it was intended to intimidate her. and that does not look good. You don't want to be the party that brings all these people in court with you. No, you know, it's nice if you own one person and they sit outside, but to have all these people come, it just creates chaos, and it creates a lot of antagonism that you don't want. So just think about what you're conveying, all your body language, the people you have in court. That's an impression that the judge will have on your client.
What I've done in the past when I was preparing folks for court was to encourage them to, like, look at the judge or look at the flag, or, you know, look that way and not towards the opposing party at all, because we know that some abusers can be very intimidating with their looks or their gestures, and we don't want anything to throw our survivors off or shut them down. And if they needed to express themselves, we would encourage them to have a pad of paper and a pen and jot things down, or scribble or doodle or something that could help keep them focused and not be distracted by their abusive partner or other people that their partner might have brought into the court. That's pretty common sense kind of stuff, huh? Okay, so basic guidelines for advocates. It's really important that you're well rested. So if you've got some court cases where you're accompanying someone to court the next day, make sure you get a good night's sleep. You want to be alert. You want to make sure your boundaries are good, your responses are clear, and you're just effective in your advocacy efforts. And advocates are a reflection of their client. We're a reflection of our agencies. We reflect on other advocates. And then how we present ourselves is important. We want to have credibility and not be a distraction to the case, but really add value to that survivor's experience in court. So this one is all you.
Yeah, so what's kind of neat about Maricopa County, we have the judges have information, and you know, just like one page about some of their preferences. Judges can have some unique personalities, so they've put on their on the website little things that kind of irritate them. And so it's really nice to know those. If you're appearing in front of a judge you've never been in front of before, just go quickly to their website and look at what they have written, just about preferences they have.
You have some examples? Stuff you see?
I can't think of anything in particular, but yeah, I can't think of anything offhand. I mean, could we click on that maybe as an example and follow that link right now, or is there a way of doing that?
I don't know.
Quick meeting?
No. Okay. Okay. But, you know, just if you're on your computer right now, just, you know, check out that website. And each of the judges has a little, like, biography and just a couple words of advice for their courtroom. So that's really helpful. You can look their calendar to make sure you have the court date right. But ECR is probably the most important thing that I talk about. Basically, it stands for Electronic Court Record, and it is a website where you can go and you can see all of the minute entries, all of what, you know, the rulings of the judge, all of the orders to appear in the case, and this is not public information. It used to be that on the clerk's website you could find a case, you could just look up by a person's name, and they've made that all hidden now. So all you can see there is, you know, the parties and things like that. So ECR is your only way to actually see everything that's been filed in the case. And I tell my clients to sign up for this because, you know, the other party should be sending you something. Well, they might not have the right address, or they don't get it in time. Your clients can go on this anytime, day or night, and see everything that's been filed even before they receive it in the mail. And all it requires is a license. They go on and they enter in their license number, and I mean, within a few hours to overnight, they have access. So, and then once they get on there, they have to add the case. A lot of my clients will sign up and say, well, there's nothing showing up. They have to actually make a note. They actually do have to like enter their case number in there. And then if they share their password with you, you can see all those documents too. So it's probably the most important resource I think that we have in the county.
So if you're outside of Maricopa County, get on the court's website in your county and see if they have similar information that you can access, and just explore. And the more information you can give the folks that you work with and the more information that you have, the better your advocacy is going to be.
So, yeah, like Doreen was kind of hinting at, it does change by county. So some of the smaller areas, you might be able to find more information on that website. I think Maricopa County is just so large that a lot of that information has been removed. But in different counties, you might just be able to put a person's name in and find out more. So, you know, like I was referring to earlier, no children in the courtroom, that's something that would vary from a protection order case to like a custody case. The judges are a lot, if you have your children with you and you need a protection order and you're going to appear in front of a judge to get that, they're not going to give you a hard time that you have to get a babysitter to get your protection order. They're not going to do that. But in a family court case, they want you to make arrangements. Criminal court is, I have a little bit of experience representing victims there, but most of what I do is in family court. But criminal court, be prepared to wait. That's something where if you have something set for a particular time, it may not happen for hours and hours. That's something you need to be prepared for. Make sure there's, someone isn't parked at a meter and is going to run out. And even just if you haven't appeared in criminal court buildings, they can be intimidating. They're just gigantic buildings down here for Maricopa County. So make sure you're in the right place, which goes back to going to a place ahead of time. And you can go to any of these buildings and sit in on any type of hearing. You can watch protection orders, contested hearings for that. You can watch criminal hearings. You can watch family hearings. Unless you're a witness, there's no reason to exclude you. So you can just sit and watch and just see how a judge is, see what their procedure is like. I think that's really helpful for people to maybe go and sit in the courtroom ahead of time and just feel comfortable in that environment. But you can look up the local rules of your court. That's on the, usually on the court's website is where they will have that, just along with the judge's little peculiarities. There are local rules that usually apply to filings and not so much, right. So, but it's a matter of just being prepared and feeling comfortable. I mean, that's number one for your clients, to just feel comfortable in that environment because they're already in such chaos in their life a lot of the times.
One of the other things, too, if you as court advocates observe something that you think is wrong, or you think that a judge is being unfair or victim blaming, or any of those kind of things that just don't feel right, you can always lodge a complaint at the administrative offices of the court. And they're like the overseeing agency for all the courts in the state. They visit the courts on a regular basis. They audit files. They follow up on complaints on particular judges or court staff. And I've met a couple of them over the past month, and they really they requested specific presentations on domestic violence. They really want to improve the court's response to domestic violence. So if there's something that you're concerned about that's happening in the courts, get on the administrative offices of the court's website, and it'll walk you through how to lodge a complaint.
Yeah, not all judges are great. I wish that they were. Not all of them understand domestic violence. And so there are some times that you might get familiar with a particular judge and recognize that they're not someone who really gets DV. And so one of the things that we do at my organization is when we have a new client that comes in and we see a particular judge and we know that judge is not very favorable towards our clients, we can file a notice of change of judge. And that's a form that you can get on the self-service center for the clerk's website. It has to be filed before any type of actual ruling is made in the case, any substantive ruling. So if they're going for a first appearance, they haven't appeared in front of that judge before, they can file a notice of judge. They are automatically granted that. They're allowed one, and there's specific criteria that you have to put in that motion, but there's samples of the motion on the self-service website, which is run through the law library in Maricopa County. So that's a really good resource. The judge will change, and then who knows who you'll get, but at least you won't have that judge who you know is not going to be fair.
Good. That's a good piece of information. So safety issues.
So it's really important. There's a couple of things that you definitely want to do. You can call the courtroom ahead of time. You can talk to the judge's assistant. You can say, we've got a hearing coming up next week. Make sure they're going to immediately want to know the names of the parties and the case number, have that in front of you. Tell them there's just some safety concerns, whether there's an order of protection or not. You don't have to have the order of protection in effect. You can just say, there's some history in this case. We would like security to be there in the courtroom, and they will have security present in the back. The other really important thing is after the hearing, they will hold back one of the parties. You always want your client to be the one to leave first. If the other side, if the abuser leaves first, they could sit in their car and they could wait and they could follow your client home. So you want to make sure your client leaves first. They have the time to get to their transportation and get out of there before the other party leaves. So you always want to be on the good side with everyone in the courtroom. Be respectful to everybody. They will work with you if you, if you're polite with them, and just let them know these concerns ahead of time so they have time to make these arrangements.
So what's a JA?
That's a judge's assistant. So if you ever hear people say JA all the time, that's the judge's assistant. That's the person you're going to be dealing with probably when you call. That's the person who will probably answer the phone.
And I've done that before in cases where somebody's abuser has been known to accost them in public or approach them in public and start, verbally or emotionally abusing them. And courts want to shut that down. They don't want that to be happening in their court. So if you can give them a heads up, at least in the downtown court, it's been more than security. It's been like an armed officer, a sheriff's deputy, or a city police officer, depending on which court you're in. And they will ask you to acknowledge the party you're concerned about, and you can nod or point, and then they will stay in that vicinity and keep their eye on that person. And it's pretty effective, and it really is supportive for survivors that might have that fear of what their partner might try to do. And when the judge is aware of that dynamic, that's when, like Alicia said, they'll hold that party back usually so you and the person you're advocating with have time to get out of the area. I just learned something. What a JA is. Mm-hmm. So it's really important. That's funny. We'll put that in. That's funny. Okay, so silent support is what advocates do for the most part when we go to court with folks. We don't want to interrupt or yell at the judge, right? We don't want to do any gesturing. Good morning, Mia. I'm glad you joined us. We don't want to do any gesturing. That includes shaking your head yes or no. And really, check your face. Check your facial expressions. And what this little meme on there says is, controlling my tongue is no problem. It's my face that needs, what? Deliverance.
Deliverance.
It's my face that needs deliverance. So really be aware of of your facial expressions, and you want to be the role model and set the pace for the person you're advocating with. They're probably going to be going through all kinds of emotions. So help them with breathing or with, like I mentioned earlier, a pad and a pen so they can doodle, like Xenia's doing right now, so that they can, be there and present at the proceedings, but not distracted and responding in a way that might put the judge off. Don't sigh. Just be quiet. Do not engage the other side, the abusive side. Let the court personnel and law enforcement take care of that. Do you have anything else to add to that?
Yeah, and we'll talk about addressing the judge, but, one way if you're in court and the judge is talking and it's crucial that you immediately say something, usually you can wait, but if there's something that you needed immediately, just tell your client to stand up. That gets the judge's attention. They should be standing up when they address the judge most of the time anyway, which we'll discuss later. But or just raise their hand or something. But judges don't like to be interrupted. It's really important to a lot of clients don't understand court procedure and so it's very important when the other side is testifying, you can't interrupt them. Prepare your clients for that. They get their chance to say what they're going to say. They should be taking notes in court. Oh, I got to make a note. I'm going to say this, or he said this, and it's really important that I point this out. Have them get used to writing notes, but you can't just interrupt a party. Judges get very irritated at that.
So it's really important for us as advocates to understand what the unauthorized practice of law is, knowing the difference between giving legal information versus giving legal advice.
Right, so generally a clue as to that will be, well, what should I do? And you can't tell a person legally what they should do. That's giving them legal advice. You can say, well, this is what the law is, and the law is available online. You can get, like in family court cases, you can get all of the code, and I think it's actually pretty helpful to have your client see what the judge is going to be making their decision on. There are different factors. 403B is the code that refers to what the judge will consider in awarding custody. So it's nice for your clients to know what the law is, but you can't actually give them advice on it. So you could give them the information, you could tell them what it is, but their decision, up to them, and you can't tell them either way. You can't really even guide them. Well, if I were you, I would do this. You really would kind of want to avoid that type of discussion.
So on the info points on this slide, the first info point very clearly states what legal advice is. We can't do that unless y'all are attorneys out there. We can't do that. But as Alicia said, we can state what the law is without any application to this person's particular situation. But it's, as Alicia said, it's up to them to decide which route to take, what's going to be best for them. We could ruin a case if in our agency's reputation, if we, took on more than we are credentialed or prepared to take on. We are advocates, not attorneys. If you want to be an attorney, go to school and, get the proper credentials. But we don't want to be giving anybody misinformation or misleading information to make their situation worse. We're there for support and information and resourcing. One of the other things I wanted to add to that, I can't remember now.
You also don't want them being mad at you if you gave them advice and something didn't turn out. That's a liability for you. Right.
So basic guidelines for survivors, and this is to help you all prepare survivors that you're working with for any kind of court proceeding, any kind of action. that is happening in court, any hearing that they have to show up to. If you do your homework and the upfront calls and arrangements, they're going to be very safe inside the courthouse. Mesa Prosecutor's Office, for instance, they have a safe room where the advocates will wait with the survivors before the actual court hearing, so they're not sitting on a bench outside a courtroom. And, if the abuser shows up, that's an opportunity for them to be mistreated again. So they've actually created a safe room in the Mesa City Courthouse. It's very cool. Court staff is going to ensure the client's safety, but again, first you've got to give them a heads up. So check with your client. What kind of fears do you have about going to court and being in the same courthouse or the same vicinity, the same courtroom with your partner, and then convey that to the court staff. So that means you've got to give yourself some prep time beforehand. And that's very important, that we take the time to make that as safe an experience as possible. Anything to add?
But keep in mind, you're not safe at all outside of that courthouse. So don't disregard parking lots, city streets. It's super important. Court is a very stressful time. It's kind of a triggering time. And so you don't want, especially after court hearings and custody cases, you will have abusers that are pretty fired up, and that is the time that they will follow your client, that they will harass your client. So you want to make sure they have a safe way home, they're not being followed, and they might feel relieved that the court hearing's over, but you want to make sure that they're following through on a plan for safety after court too.
And some officers will escort you out to your vehicles if you give them a heads up and they make arrangements to do that.
So as I was starting to say earlier, there are ways to get the judge's attention. One of them would be to stand up. In court, normally when you are in the middle of a hearing, anytime you address the judge, you would stand up. Anytime you were talking to the judge, you would stand up. A lot of judges don't really expect that kind of formality out of unrepresented parties. So I think it's a good idea maybe in the beginning of the case to stand up the first time, and it's okay to ask the judge questions. Say, Your Honor, would you prefer that I stand up every time I address you? And maybe the judge will say, that's okay, you can remain seated. Sometimes the judges will have the parties sit at the table to testify. Other times the judge will want the person to go up and sit in the box and testify. So that's another thing. I never know when I get into court which the judge is going to want, and I kind of follow the judge's lead. The judge will just say, you can just testify where you're at, if that makes it more comfortable.
I've seen podiums where they stand at to testify, too.
Yeah, that's another. So it just depends on the judge's procedure. Have your client be prepared for any of those options. Sometimes they may feel more comfortable sitting at the table because the other party is not in their direct line of sight. So, you could ask, would they be able to just stay at the table? That might be a better option for them, so they don't have to look at the other party. But there's definitely a procedure. Make sure you know that procedure so you can kind of warn them ahead of time. A lot of times just even sitting at the right table, sometimes they come in and they won't know which side I'm sitting on. If you're coming into court a little bit early, you can ask the judge's assistant, the JA, or any of the staff who's there while the court is not in session. While the judge is not on the bench, you can say, which side, I'm the petitioner, which side do I sit on, just so that they don't feel uncomfortable. Just another tip, you don't want a lot of shuffling of papers around. You want them to only have on the table the papers that they really need for that hearing, because they will get a little flustered and a little stressed out and start shuffling papers around, and that just adds to the confusion. Yeah, so I think Your Honor is super important. You don't want to say, Judge. You would never, ever address a judge by Judge. Judge so-and-so. It seems stupid because that's their name, right? But no, you always say Your Honor. It's considered less formal. It's considered a little disrespectful to just say Judge Smith or whatever. You want to say Your Honor every time when you speak. And again, you definitely do not want to talk over the judge or the other party. You want to wait till your turn. So, again, if you needed to get their attention, just raising your hand or starting to stand up is a good way to get their attention. So like I said, you don't want to bring like a giant party of people. Judges do not like that. It's seen as like an intimidation, right? No posses. Them at home. It's nice to have maybe someone out in the hallway, but it's distracting if they come into the courtroom and there's 20 of them. The judge does not like that. And like Doreen said earlier, make sure that your client is telling their friends and their family to be dressed appropriately for court. Take the hat off, things like that. They're pretty serious about that. And have them just sit there quietly. Make sure they are not doing any of these facial expressions or gasping or, you're in a court. This is still as casual as Arizona can be sometimes. This is still a courtroom, and the judge will hold it against your side if there are people that are making your client look bad.
So this is the booklet that Stacy will provide the link for in the email that she sends to you. So now is the time that we'll open it up for any questions or comments that you might have about the material, any specific questions you might have about some advocacy that you're doing right now. Feel free to use the chat box to ask anything that you might have. And if not, then we're done. Anything? Christina, Mia, anybody?
And I'll just do a shameless plug for Community Legal Services. We're a legal aid organization. We represent clients based on low income. So please send your clients our way if they need help with protection order cases, family law cases, housing. We do all kinds of civil legal aid. So if they meet the income requirements, we do a lot of advocacy, but we do also go to court at times with clients to represent them, and everything is completely free if they qualify.
And is there an office for community legal services other than Phoenix?
We have them all over the state, actually. We have an office in Kingman. We have Yuma. We have Prescott. So we've got offices all around that cover most of the areas of the state. So our website is clsaz.org. You can go there. The intake process is also really simple. You can just call on the phone even and go and have an intake done there. And I think Stacy's going to write that in. Yes, there you go.
clsaz.org.
I do recommend do not apply online. You can, but it's kind of an unwieldy process. It's better to just pick up the phone.
So Mia's got a question. I have a client whose order of protection is expiring against the abuser. He just went and filed an order of protection against my client. Any tips on how or whether she should, any tips on whether or how
she should respond?
She should even respond.
She should definitely respond. She should request a hearing. You can request a hearing anytime. While it's in effect, that entire year you can request a hearing. And I help a lot of people actually. I don't just help people get them. Unfortunately, I have to help people who have orders of protection against them from the abuser. It's a tool they use to intimidate.
Discredit.
Yeah, exactly. So I do help a lot of people on that.
So has she been served? Has she been served with the order of protection, Mia?
Yeah.
She has been served. So she can call for a hearing.
Yeah, and you can go down to the Protection Order Center and just, it's a simple form. You don't even need to put a reason. You can request a hearing. And then when the hearing happens, the burden is actually on the party that got the order of protection to show that it's needed. So it's not an uphill battle for your client. Okay, let's go back and see what those other questions were.
Yes, of any POC.
What's the POC?
Any Protection Order Center, is that what you're asking?
Oh.
Protection Order. Oops.
Yes.
Yeah, so you want to go to you really want to go to the jurisdiction where it was. It makes more sense to do that, to go in front of, or in that court where the order of protection was. I've never had a case where I've done one that wasn't at that particular, at the same place.
Okay, let's scroll up and see what Mary Ann's question was. Doing all the way east, and they live in Buckeye.
Oh, okay.
Yeah, he probably doesn't want her to call for a hearing.
Right.
But again, like Alicia said, it's on him to demonstrate to the judge why that order is needed.
So is this then, this would still be in Maricopa County? Is it in a small jurisdiction, or is it a Superior Court case? Yeah, you can go and file anywhere for the hearing, because you're filing in the clerk of court. So as long, if it's a Superior Court case, she can definitely go and do that. Just where, any of the courthouses in Superior Court.
Cool. I'd be interested to know how that turned out, Mia. Let's scroll up and find Mary Ann's question. Pressure? Am I pressuring? Okay. Mary Ann's got a case of domestic violence, from what I understand. Victim can't drop a case of DV or sexual violence if the police has been involved. Only the attorney can.
Right, and I don't practice in criminal court, but I used to. And yeah, it's up to the prosecutor if they want to drop a case. They can pursue the case without the cooperation of the witness. Generally they won't, unless it's a really extreme case and they have other evidence that's enough to support it. But, so I'm reading that. Police going in. They do need to make a case.
So if, the way the law is written, if law enforcement has probable cause to believe that domestic violence has occurred, they should write a report and or make an arrest. The victim's not supposed to need to say, I want to press charges. That's old school. That's so 80s. It's considered a crime against the state, and if law enforcement have probable cause, then they're supposed to, like I said, arrest or write a report, and then let the prosecutor make that decision. Some cops we've heard from victims, though, are still not proceeding and not even writing a report unless the victim says they want to press charges. And I think they're trying to, it's either lazy cop stuff or they're trying to gauge if that victim is going to be cooperative and testify, etc. But that's not the cop's job. They've got probable cause. They should arrest and or write a report.
Right, and so, a lot of them get dropped because the prosecutor will think, there isn't really enough evidence here. But, if the officer does a good job and is documenting if there's injuries, especially there's photos taken, things like that, they can make a case without the witness there. you know, that's maybe education that the police need. But yes, I mean, you can do a case without the prosecuting witness because you will have the officer there to testify. Even if the witness shows up and isn't cooperative and testifies, well, it didn't happen, or, you know, whatever, they're intimidated. If the police had done their job, hopefully there would be enough evidence that they could still make the case.
So, yeah, some prosecutors will look at everything they have on the case and weigh if they think they'll be successful, if there's enough evidence, if they've got a cooperative victim that's going to testify, all those kind of things.
Were there other things up there we missed?
I think we got it. I think we got it all. And that, you know, that's another benefit of advocates, too. The more information that the victims and survivors we work with have, the more support that they have, the more likely they are to follow through on these cases. And that's a really important function that we serve, that giving the support, the encouragement, the information. And then, you know, that takes away a lot of the apprehension and the fear that a lot of victims go through.
Good. That might be easier. Yeah.
Oh.
Yeah. So is this attorney, what type of case are we talking about here? That probably makes a big difference.
Somebody that they retained?
I mean, if it's someone they retain, they can fire their attorney at any time. If it's, you know, a public defender, in certain cases, you're a public defender, you have a little more trouble getting rid of that attorney. So I guess it kind of depends on which the case is, Carolyn. Oh, I guess I answered the question.
Cool. Okay, anything else? Any curiosities that you have? Well, we have our attorney locked in the room here. You know, it has vast amounts of information for us that aren't attorneys.
One thing that I do is I have a copy of the actual sort of script that the judges are supposed to follow in protection order cases. I use that. I create a document for my clients based on that, with the order of the case. So here's who's going to go first, and then here's how to enter something into evidence. And so this works for order of protection cases, but even in family court, I share with them the procedure. It's really good for them to know that. That's something that you're not doing unauthorized practice of law by telling them the procedure in court. So I can certainly help. Yes. So can arrange to have that. I can give you the copy of what I use that shows this person goes first, and then after that they cross-examine, and I explain that means then the attorney will ask you questions, or the other side, the abuser, may be asking you questions. Be prepared for that. And then after that, you get the last word. So I tell people what the procedure is, and that helps them a lot, so they don't just go in there and, is it my turn to talk now? I go over what objections are, what it means if something's sustained or if it's overruled, because a lot of times they don't know.
Do you have that procedural handout for order protection cases, for family court, for criminal court?
I don't have anything for criminal court because I don't do criminal court, but it really is kind of the same procedure. There's usually one person testifies, then there's a cross-examination, then there's a redirect examination after that. Could I define these three terms now? What were the three terms I said?
Objections.
Oh, objections, or are you talking about the cross-examinations? Well, I'll go ahead and tell you anyway. Cross-examination, objection, yeah. So when a witness and the other party doesn't think that what they're talking about is relevant, or she's allowed to say what they're saying. So I'll use hearsay is talking about something another person said. If they're going to figure out and they go, oh, this sounds like hearsay. And they're going to object and they're say, this is hearsay. This is something that was said out of court, and so it's not necessarily reliable. Oops. Can you still hear us? Is everyone hearing us still fine? I'm going to keep talking. Let us know if you can't hear me. Everyone's typing now. Everybody can hear me apparently. I don't know if you missed something, but I'll try to do this again. Let us know if we're still breaking up. So an objection would be someone saying this is hearsay. This is basically something that was said out of court. So it shouldn't be allowed in. So the person who objected is supposed to say the reason that they don't think that evidence should be in, for example, that this was an out-of-court statement. Then the person who's testifying or their attorney would have the opportunity then to respond to that and say, well, no, this is, for example, in family court cases, they generally allow you to talk about what the kid said. So you'd say, well, this goes to the best interest of the child. That's what this whole case is about. So it's not hearsay. You should allow it. And the judge will say, okay, well, then I'm overruling that objection, which means I'm allowing the witness to answer. And sometimes the judges will be nice. Overruled, the witness may answer. But so the important thing to remember is if the person testifying hears the word overruled, they can keep talking. If they hear sustain, that means that that person can't continue to talk about that train of thought. So it's generally something you probably want to have written down for your clients. We have a question, does evidence have to be submitted? It depends, and the minute entries will usually tell you that. For family court cases, they generally, we have something called disclosure, which is just what it says, disclosing the evidence to the other side. There's no showing up and ambushing the other side. Your evidence has to be submitted to the other side, any documents, list of witnesses, at least 30 days before. And it will say this in the minute entries, usually exactly what the deadlines are, but it's generally 30 days before. They have to know what you plan on using. In real life, this isn't always followed, and sometimes I will go to court and this wasn't disclosed to me till a week before, and I'll object, and the judge will say, well, have you had a chance to look at it? Yeah, okay, I'm going to allow it. But you don't want to rely on that, because if it's an important piece of evidence, you don't want it to be excluded. For protection order hearings, there generally isn't any type of requirement. I like to, anyway, go ahead and get the exhibits ahead of time to the court. You can just bring them down to the judge's courtroom. You can usually, you would call them, and there's phones like in the Superior Court. There are phones in the hallway. You call and you say, I'm here to give some exhibits for the hearing, and they'll come out and they'll take the exhibits from you. So they'll mark them ahead of time. This is Exhibit 1, this is Exhibit 2. So then when your client will go into court, they're sitting at the table already, and then it's not as stressful. Sometimes you get things, though, very late in the game, and you don't have a chance to prepare it. That's fine. You can also do it. It just takes a little bit of time out of your hearing to say, well, I have this marked as Exhibit 1, and can you mark this as Exhibit 2? And it takes a little bit of time. But generally with protection orders, you don't have to have that ahead of time.
I've done that both ways with some of the survivors I've worked with. Some of them have been able to, print off text messages, threatening text messages they've gotten from their partner, threatening emails, those kind of things. And some have turned it in beforehand. We've made arrangements for that, or some have turned it in the day of the hearing because they know they have to demonstrate to the judge why they need that order of protection.
Also, I would add, one of the best things that you can do is have a well-written petition for an order of protection. The judges are very serious about not allowing anything in as testimony that isn't written in the petition. So make sure that you are writing in detail. If there's a lot of different incidents, it really helps to put the date when this happened, and it generally can't be more than a year there are some circumstances where it can be, but really you should try to confine it to the past year, things that have happened. So even if, if it was 9 months ago, they can still get the order of protection.
Any other questions? Curiosities?
I think I didn't discuss the whole procedure with the cross-examination, and I probably should talk about that. So generally, in hearings, the petitioner usually is, the person who goes first. They will testify, and then after they testify comes cross-examination, which is the other side's chance to ask them questions. Sometimes the other side thinks it's just their chance to be like, well, he said this and this isn't true, and that's testifying. That's not, you have to ask questions. It has to be in the form of a question. So I generally tell people to say, isn't it true that, that's a good way to say it, isn't it true that you really didn't do this when you said you did? And be prepared for that person to say no, and it's kind of a useless question sometimes. They're going to deny it, but it brings it up to the judge's attention. It goes to their credibility. And then, so after that person has a chance to ask you questions, then you get the last word. And that's what we call redirect examination. You're redirecting it back to that original testimony, and you're saying, well, he just asked me this, and I want to clarify. Because when you're being asked a question, a lot of times it's just yes or no, and you can't really say more, and the judge won't allow you to expound on it. So you have that last word. So let's say your client is female and the other side is male. So if your client's the petitioner, or in a protection order case called the plaintiff and defendant, your plaintiff would go first, testify. Then he would be able to ask her questions, and then after that, she gets to go back and testify again as the redirect. Then it would be his case. He testifies, she asks him questions, which is the cross-examination, and then he gets to redirect and finish up. In a protection order case, you don't even need to get to the other side. Generally, they do go to the other side. But in protection order cases, the judge has to find enough evidence to even hear from the other side. So that person who wants to have the order remain in effect, they would be the one who's going first and saying why they still need to have that order. If a judge doesn't even find enough evidence, case is over, then it's dismissed. But generally, the judges do then want to hear from the other side, from the person that doesn't want the order of protection.
Sure, Carolyn. Are you in a legal clinic? And if so, what one? Right on. Sure. Yes, and any of you, if you're working with other advocates or people that you think this information would be helpful to, please share it. And you can refer other folks to the Coalition's YouTube channel, because we're going to have this archived on there, so people can view it if they couldn't make it to the webinar this morning. So keep that in mind also. Anything else? We'll start wrapping it up.
I just wanted to add bear down. I went
Bear down. That's pretty funny. Okay, so again, you can direct people to, you bet, Marianne, you can direct people to our YouTube channel that might want to view this webinar at their leisure. Stacy will be sending out an email with the link to download this booklet, How to Represent Yourself in Family Court. Alicia will be sending us those procedural handouts that she made for the folks that she works with, and we'll send that out to the folks that attended. And thank you very much.
Yeah.
We got a couple of people typing. Yeah.
Thank you.
Thank you.
Thank you. Thank you.
The email I'll send out, it'll include the slides, any resources the link to our YouTube channel. So if you weren't able to watch this, or maybe have coworkers that weren't able to, you guys can watch it in the future. And then you can respond to my email if you need a certificate. So I will try to get that email out to you guys as soon as possible, either today or possibly Monday. We've got to upload the video link into YouTube.
Okay, folks. Yeah, Mia, everybody, have a good weekend. Take care of yourselves.